Good morning to you all. Welcome to the 74th session of our Jesus González Amuchastegui Permanent Seminar. Today, we have the pleasure of welcoming Professor Dr. Martin Borowski from the University of Heidelberg. Professor Dr. Borowski is Professor of Public Law, Constitutional Theory, and Philosophy of Law at the Faculty of Law, the aforementioned German University. He obtained the degree of Juris Doctor with a dissertation entitled Fundamental Rights as Principles. Subsequently, he obtained the degree of Professor of Law with the habilitation thesis Freedom of Belief and Conscience as a Fundamental Right in the German Constitution. Both degrees were obtained at the Christian Albrecht University in Kiel under the supervision of Robert Alexi. He specializes in topics relevant to dogmatics of fundamental rights in Germany and the philosophy of law. In this sense, I will highlight the topics of the concept of law, morality and normative of law, the structure of fundamental and human rights, subsumption, and balancing as methods for the application of fundamental and human rights and law in general, as well as law and religion regarding the dogmatic and constitutional theoretical dimension of fundamental and human rights, of freedom of faith and conscience. Some of his work are available in Spanish. His book, Elementos Esenciales de la Dogmática de los Derechos Fundamentales, translated by Arnulfo Mateos, was published in Tirán Leblanc in 2022. Yesterday marked exactly 2 years since its publication. Yesterday. It's probably one of his most relevant works. Likewise, it is available his work, La estructura de los derechos fundamentales, translated into Spanish by Carlos Bernal Pulido, and was published as the issue 25 of the famous collection of Teoría Jurídica y Filosofía del Derecho, promoted by Luis Villar Borda at the Universidad del Externado from Colombia in 2007. In this context of the Universidad del Externado, his article, The Drittwirkung ante el trasfondo de la transformación de los derechos morales en derechos fundamentales, has also been recently published in 2020, issue 45, in the Revista de Derecho del Estado, with the Spanish translation by Arnulfo Mateos. In Spain, he also published his article, La restricción de los derechos fundamentales, in the issue from May-August 2000 of the Revista Española de Derecho Constitucional, with a translation by Rodolfo Arango, that, if I am not mistaken, correspond to the sabbatical year he shared with you in Kiel. I would also like to highlight the book he edited in German and English under the title Modern German Non-Positivism from Radbruch to Alexi, published by Mort Siebeck in 2019, which has probably brought together the best of the Alexis school. In short, Professor Borowski is not new to the academy in Spain, in Spanish, although he perhaps has more recognition in Latin America than in Spain, and it is a pleasure and an honor to have you here. The title of his lecture is Kelsen's Pure Theory of Law, Legal Power and Derogation, and actually corresponds to a classic theme in the theory of law. Thank you, Professor Dr. Borowski, for accepting our invitation. Our custom is for the speaker to speak about 40 or 45 minutes, and then to open a discussion with those present in the room, as well as with the public who are following your presentation online. But of course, We are attentive to your preferences. Thank you again, and I give you the floor.
Well, yeah, thank you very much. First things first, I shall thank Professor Sauka-Kano for the kind invitation to speak here today and for his generous hospitality. And I thank you for your time, actually, of coming here on a Friday. You could do other things, and actually listening to the aspects I'm going to speak about today. I think this has also practical implications, and I understand that Dr. Matthias Duran yesterday, when he gave his presentation, promised that I would also answer questions on constitutional rights, and I'm of course happy to live up to promises that he made on my behalf. That's perfectly fine. I think the topic today also raises some questions, so this is not an attempt to move things, but it's just an invitation if there is something you have heard about things that I have covered in the past and want some clarification, that's of course perfectly fine, as long the time permits in the format we have here. Yeah, I'm going in my presentation to focus on the hierarchical structure of the legal system according to the pure theory of law generally, and on the relation between the hierarchy of conditions based on legal power or legal competences and the hierarchy of derogation. Which legal norm derogates from which other legal norms in case of a conflict? The pure theory of law, embracing the doctrine of the hierarchical structure of the legal system, is a positivistic theory. I am neither a Kelsenian nor, more generally, a legal positivist. To be sure, an analytical inquiry into the structure of legal systems is relevant for both legal positivists and non-positivists, all supporters of natural law. I will use natural law and non-positivism as synonyms. One can make a difference, I don't here today. Non-positivists assume that there is a necessary connection between law and morality, the connection thesis, but they typically support the weak connection thesis. In Robert Alexi's version, positive law counts as valid law unless there is extreme injustice. If there is injustice, but not extreme injustice, it remains to be positive law, valid positive law. If the high threshold of extreme injustice is not crossed, unjust positive law counts as valid law. This is to say that on this side of the threshold of extreme injustice, for natural lawyers, first, authoritative issuance, and second, social efficacy is key. The two criteria that are the only relevant criteria for the identification of valid law for legal positivists. So this is basically the same problem both camps have. Unless, by way of exception, moral correctness rules out certain content from positive law, natural lawyers, legal non-positivists need to structure the legal system in a hierarchical order, both in terms of legal power unfolding over a chain of law application and law creation, and in terms of derogation. Thus, the issue of hierarchy is relevant for both legal positivists and natural lawyers. Beyond my interest and my efforts in legal philosophy and constitutional theory, I'm undertaking research and I am teaching public law, mostly constitutional law, and some European law also. These two strands of my research, legal philosophy, public law, and teaching, are looking from different standpoints at the issue of hierarchy. In constitutional law, derogation is key. It's actually the only thing people look at, derogation. In case of a conflict between and among different legal norms, the question which norm prevails over which other norms is front and center. It is clear that constitutional norms derogate from legal norms established by parliamentary statutes, not the other way around. This implies, among other things, that parliamentary statutes need to be interpreted in conformity with the Constitution, not the other way around. In federal states, the hierarchy of derogation may well be more complex, as I explain here today. For example, in German, every form of federal law takes precedence over every form of state law. If federal law is enacted inside the federal competences, so competences is an issue here, and this might actually become also relevant if we look at EU law. Competences, and otherwise formally and substantively lawful, of course. By contrast, when legal philosophers or legal theorists inquire into the phenomenon of the hierarchical structure of the legal system, they are focusing, following Adolf Julius Merkel, Hans Kelsen and the pure theory of law, on the hierarchy of conditions in which legal power or legal competence, in German Ermächtigung, is key. While Hans Kelsen does not even address the issue of derogation, according to Adolf Julius Merkel's explicit statement, the derogation between and among different levels of norms is a contingent relation. It does not necessarily run parallel to the hierarchy of conditions. This is the key point. For Merkel, it is not only the maxim, the Roman maxim, lex superior, derogat legi inferiori, that counts as a contingent matter of positive law. It is also the maxim, you probably know what's coming, lex posterior, derogat legi priori, expressing the assumption that later legal norms take precedence over earlier legal norms at the same level of superiority, actually. This is the order of the maxims. This, of course, the last statement by Merkel, raises the question whether a legal system in which legal norms can never be repealed, amended, or changed can actually be imagined. I will return to the issue later in my presentation, so soon. Even though the hierarchical structure of the legal system is front and center in Kelsen's two editions of the Pure Theory of Law, 1934-1960, and is intimately connected with Kelsen's basic norm, his reconstructed legal norm, his theory of interpretation, his monistic interpretation of the relation between national law and international law, it was actually his younger colleague, Adolf Julius Merkel, who developed the theory of the hierarchical structure. Kelsen adopted Merkel's theory from 1923 on, and there is only one respect in which Kelsen developed this set of ideas in the doctrine. Further, Merkel's reconstruction already embraces a source norm, Ursprungsnorm in German, source norm, but Kelsen gave the idea of the basic norm, Grundnorm, more philosophical depth. It doesn't have this with Merkel, I have to admit. Apart from this aspect, the doctrine of the hierarchical structure of the legal system is based solely on Merkel's ideas and writings, even though, this is now a little scandal, even though Kelsen does not cite Merkel even once in his chapters in both editions of the Pure Theory of Law, and not in the General Theory of Law and State, the book in between he wrote in the US when he was already emigrated following the Nazi persecution in Germany. These three books, the main works of the Kelsen's classical period from 1922 to 1960. There was some acknowledgement by Kelsen elsewhere, but by modern standards, I would argue too little and too late. So Merkel, in some sense, is key. Unfortunately, Merkel's writings are not well known in the international debate, since there have been few translations in other languages, and if so, rather recently. There are some, we discussed this, I think, here in Madrid, but not that many. This is a true pity, for Merkel's writings are not only helpful in understanding Kelsen's chapters on the doctrine of the hierarchical structure, Merkel's writings also go in some respects beyond the parts that Kelsen adopted into his famous books. So there's actually more from Merkel than went into Kelsen. Most notably, Merkel's writings on the hierarchy are concerned with two connected but distinguishable issues. First, necessary levels of norms in a legal system. Which levels do we need to have that there is a legal system? And typical levels of norms in liberal democracies. When Merkel began to develop the hierarchical structure in a series of brilliant articles in 1915, from 1915 to 1922, culminating in a book chapter, 1923, he inquired into both issues, necessary and typical levels. Then Kelsen began to adopt Merkel's theory, but only the theory with an eye to typical levels in liberal democracies. With translations of both editions of Kelsen's Pure Theory of Law, Merkel's theory of typical levels became famous, even though as Kelsen's doctrine, so to speak. And Merkel's famous article, the Prolegomena, the last article by Merkel, then Merkel focuses completely on typical levels in liberal democracies. So even in German, it's only about the typical levels. This is to say that Merkel's truly interesting theory of necessary level has largely been neglected in the debate. So I think we will give this theory kind of 5 minutes of fame here in this presentation, although I have to say that I will correct his theory, but this is not to say that he is wrong, but this is something interesting he did. Good. For Merkel, there are not two hierarchies. This is important to understand if you approach this from the legal theory perspective. There are not two hierarchies, conditions and derogations. There is only one hierarchy, one and only hierarchy, characterized by the relation represented by the hierarchy of conditions. So it's about Ermächtigung, legal power, competences, that's it. And then there is the additional question, whether and to what extent the hierarchy of derogation runs parallel, yes or no. The relation represented by the hierarchy of conditions turns on legal power. For the norm imposing a condition confers legal power to create other norms, the norms subject to this condition. The norms that impose conditions on other norms are understood as higher norms, these subject thereto as lower. There was some confusion at the beginning, pyramid, upside down or right way, but this was the final solution. The distinction that H.L.A. Hart, the great British positivist, later in 1961, claimed to be the key to the science of jurisprudence, quotation. The distinction between primary and secondary rules can be found in clear language in Merkel's Prolegomena, the article from 1931. He distinguishes, my translation, rules for human conduct, Regeln menschlichen Verhaltens, Hart's primary rules, and rules that govern the establishment or creation of these rules of conduct, Regeln, die die Aufstellung oder Erzeugung dieser Verhaltensregeln regeln, Hart's secondary rules. At the apex of the hierarchy, one finds Merkel's source norm. I think this would now be the time to start with the modest presentation. Yeah, it's very modest. At the apex, one finds Merkel's source norm. This exhibits the characteristics of Kelsen's basic norm. It creates the unity of the legal system as one function. The second function is it is a norm that is thought, not issued as positive law. Third, it enthrones and legitimizes the authority or legal power to create law. It's the start of the chain of legal power. And fourth, it has itself no substantive content. It's completely empty. It's pure power. The basic norm, I shall use this term in as follows, vests law-creating authority. Insofar as the typical levels, we will have a typical level soon, then the next level is the Constitution. Assuming the norm is an act of law creation alone in the hierarchy, it does not count as an act as of the application of law, so creation alone. And then at the very bottom here in my on my slide is the coercive act. No, it's fine. Still, sorry, this good intent, but the dramatic unfolding says we shall reveal this later. To focus on the coercive act, at the very bottom there is the coercive act. This means carrying out the sanction by officials of the legal system. In private law, this would be bailiffs. So someone comes and if you don't pay, so to speak, someone comes and takes your TV set and your car and your PlayStation or whatever valuable assets you have at home. For Merkel, performing coercive acts represents the application of law, but not the creation of law. And there's something correct to that. The coercive act is actually a fact, or a set of facts. It is not a legal norm. This is, I think, important. These facts are legally relevant and thus part of the legal system. The legal system does not only consist of norms, it also consists of facts. As facts, they cannot be, strictly speaking, part of the hierarchical structure of legal norms. We have to distinguish between the hierarchical structure of legal norms on one hand and the hierarchical structure of the legal system, which embraces legal norms, ought, and legally relevant facts, is. According to Merkel's explicit thesis, now, necessary levels, only the basic norm and the coercive act represent necessary levels of a legal system. He speaks of a dualism of forms of law. Not norms of law, but forms of law, because the coercive act is a fact. Actually, now, Merkel thinks this is enough for a legal system. It is not. The answer is, the question is interesting, the answer I think is not particularly convincing. The first problem is that the relation represented by the hierarchy of conditions, which is for Merkel characteristic of the hierarchical structure, is a relation between and among norms. He says this. Now the coercive act is a fact. This doesn't work. He overlooks that, I'm afraid. Merkel thinks that the coercive act can be included in the hierarchy of conditions between and among norms. I have argued in an article in Ratio Juris with an eye to the typical levels, but this applies also here. Individual norms, according to Kelsen, still need further concretization. Kelsen himself says that. This is to say that there needs to be a level of what I would call fully individualized and concretized norms at the very bottom of the hierarchy of legal norms, above the coercive act, even below Kelsen's level of individual norms. The coercive act is located at the very bottom, and the relation between the fully concretized, individualized legal norm and the coercive act now, and this is why I think it's necessary, is a relation of is-ought correspondence. Now, if you would be so kind to change the slides. Now the moment has come. Yeah, thank you. So this is-ought correspondence here. Why do we need this? We need this because the coercive act is only a part of the legal system if the sanction that the bailiff or marshal applies in fact corresponds precisely to the sanction that, according to the fully individualized and concretized norms, ought to be applied. If what is done is precisely what ought to be done. If this doesn't correspond, the fact is not actually designated as lawful. The level of fully concretized and individualized norms marks the end of the hierarchy of legal norms and the end of the relation represented by the hierarchy of conditions. Being the final phenomenon in the chain of norms, it marks the transition from ought to is. With the debate on the basic norm, there has been much emphasis on is-ought at the apex of the hierarchy, but I think at the bottom we have to be concerned about this transition too. First problem. Now this is the modern problem. The second problem is that this reconstruction still here is too scarce to make sure that law can fulfill its specific functions. To borrow Lon Fuller's famous phrase, law is, quote, the enterprise of subjecting human conduct to the governance of rules, close quote. Where are these rules here? They are not there. Where are the rules that subject human behavior? Where are the rules to provide guidelines for human conduct? Now, this point was made early by Hans Nawiaski, that we need some form of general norms, can be single level, can be a more complex structure, but we need some rules that guide human behavior that are then the basis, they are applied, and then fully individualized and concretized norms result, and then the transition from this fully concretized, individualized ought to is can take place. So I think this is what a minimum system looks like. This is a bit more than Merkel would have us believe, but I think, at least I think his question is very interesting. Good, so now this is the necessary side. Now, in reality, there's rarely only the minimum that we need for a legal system. There are typically a few more levels in liberal democracies. There are different types of general norms: constitution, parliamentary statutes, and regulations. And I just move to the fuller picture here. We have here constitution, parliamentary statutes, regulations. Federal states is even more complex. I left this out here, but it can of course become more complex. It follows basically the same pattern. What is more, both international law and supranational law, European Union law, need a place in the hierarchical structure. And what about customary law, internationally and domestically? How can this be done? So there are all sorts of problems with the hierarchy, and Kelsen dealt with some of them. At the level of individual norms, there are different types of individual norms. This is here mentioned: administrative acts, judgments, legal transactions, contracts. It's all concretizing the law. But I hasten to add, with an eye to an example given by Merkel, that inside the set of individual norms, those are not vertical sub-levels in terms of conditions. They generally boast all of the same level of individualization and concretization, even though some of them derogate from others. So there's something complex going on inside this level of individual norms here. For the sake of simplicity in our inquiry into the relation between both hierarchies, the hierarchies of conditions and derogation in what follows a legal system with these elements here shall be in the limelight. Good. Characteristic of the hierarchy of conditions, independent from the number of levels, is, now quote, it's Kelsen, the relativity of the contrast between creating and applying the law. According to Kelsen, most legal acts represent both the application and the creation of law. Establishing the Constitution counts as the application of the basic norm and as the creation of the Constitution. Enacting parliamentary statutes counts as both the application of the Constitution and as the creation of statutes. Adjudication counts both as the application of statutes and as the creation of individual norms, and so on. There are, he continues, only two phenomena in the hierarchy that do not exhibit that dual nature. The presupposition of the basic norm, apex, is law creation alone. The coercive act, bottom, is law application alone. The level of fully individualized and concretized norms mentioned above shows that Kelsen's transition from the level of individual norms to the coercive act, two different transitions take place. First, individual norms are concretized or even individualized even further, giving rise to the fully individualized and concretized norm. And this is between and among norms relation, and the transition from the final norm here in the hierarchy to the coercive act then is a transition from ought to is. Good. Now that the hierarchy of conditions has been outlined, the question is, which role, if any, does derogation play in this hierarchy? As already mentioned, Kelsen does not address the issue of derogation in the hierarchy explicitly. He says actually nothing. It's completely surprising. From a public law perspective, completely surprising. This somewhat astonishing fact may have to do, I'm speculating, with international law. Kelsen was quick and firm to rule out a dualistic reconstruction of the relation between international and national law, because this would not be conducive to the cognition of law as a unified and comprehensive phenomenon. He was firm, dualism is as a form of pluralism doesn't work. It's impossible, doesn't work. From the standpoint of legal theory, for Kelsen, monism with primacy of international law and monism with primacy of national law were equally possible. The preference is, he claimed, a matter of political considerations, not a matter of legal reconstruction. Against this backdrop, the assumption that the hierarchy of derogation necessarily runs parallel to the hierarchy of conditions may have had unwelcome consequences. Then primacy means not only being higher in terms of the hierarchy of conditions. If the basic norm is above international law, then international law, so to speak, delegates national law, but also necessarily then higher in terms of derogation. As a consequence, monism with primacy of international law would have necessarily meant that all forms of international law derogate from all forms of national law. This consequence could simply not be reconciled with contemporary fundamental doctrinal assumptions on international law in the national legal system at Kelsen's times. And from a German perspective, I might add, this has not much changed, actually. So this is still a problem. This is why Kelsen, one might think, had to keep the hierarchy of conditions and the hierarchy of derogation separate, or at least had to leave the issue of the relation between both hierarchies sufficiently open, and this is precisely, I think, what he did. It's a speculation, but we may have a debate on that if you wish. There are, however, passages in Kelsen's works from which one can infer implicit assumptions on derogation. For example, he claims that the Constitution sets limits to parliamentary statutes and not the other way round. This is, however, placed in perspective by his notorious theory of normative alternatives and his equally notorious claim that even wrong interpretations of positive law become lawful if entertained and pronounced by courts. To be sure, I shall not inquire further into these complicated and, I would argue, less convincing elements of Kelsen's theory, but we, of course, can have a debate on that if you wish to. In short, Kelsen is not particularly helpful on the issue of derogation. Merkel actually discusses the issue of the derogation in the hierarchy explicitly, but only in his last statement on the doctrine, the prolegomena, and only briefly. In abstract terms, he is quite clear that the hierarchy of derogations does not necessarily run parallel to the hierarchy of conditions. What is more, derogation is not, according to him, that it is there, derogation at all, a necessary element in every legal system. The latter statement may even be more surprising than the former. At any rate, against the backdrop of Merkel's theory of only two necessary levels in the hierarchy, this is consequent. If you only have the basic norm and coercive acts, then there can be no derogation. Derogation is not an issue. And the basic norm is pure legal power without any substantive content. And how can there be a conflict, as so to speak, a prerequisite for a conflict? How can there be a conflict if one norm has no substantive content and the other isn't actually a norm, it's only a fact? So the derogation plays no role in this here. Good. Now, but Merkel extends his statement also to typical levels, and we shall move on to typical levels. Merkel gives an example for an act that is, he would have us believe, higher in terms of derogation, but lower in the hierarchy of conditions. He uses individual acts of different instances in the judiciary. A lower instance issues an individual norm in the form of a judgment. We know that. The higher instance repeals this judgment and issues a different judgment. There can be little doubt that the individual norm of the higher instance takes precedence over the individual norm of the lower instance. This is the point of having actually lower and higher instances. So that the former derogates in some higher instance, derogates in some form from the latter lower instance. So far, so good. But Merkel claims that the individual norm of the lower instance imposes a condition on the individual norm of the higher instance, because the individual norm of the higher instance would not exist without the individual norm of the lower instance. With all due respect, this misunderstands what condition in the hierarchy of condition means according to his own theory. The individual norm of the lower instance does not grant the legal power to enact the individual norm of the higher instance. This is simply not true. This legal power is granted by general norms, typically procedural law and parliamentary statutes. That the higher instance does only have the legal power to review if the lower instance has already handed down an individual norm in the form of a judgment is obvious. Otherwise, there was nothing to be reviewed. This is, however, a requirement, I would say, not a condition in the specific sense of the hierarchy of conditions imposed by general legislation. What is more, it is important to understand, I mentioned this already, that individual acts are generally not on different levels on the hierarchy of conditions. The level of individualization and concretization is basically always the same, and which kinds of individual norms may be enacted by whom in which situation follows complex considerations beyond the hierarchical structure characterized by the hierarchy of condition. That Merkel's example is less than convincing does not mean, however, that this thesis that derogation is a contingent matter of positive law must be wrong. After a brief analysis of the necessary levels, the issue of derogation at the top and the bottom of the typical hierarchy of national law is straightforward. The problem lies in the middle. The basic norm is higher than the constitution of conditions, but devoid of content, as already mentioned. So here at the very top, derogation is not an issue. I should mention that from a non-positivistic point of view, a positivistic basic norm that lends non-moral normativity to positive law might actually not be necessary. So if you are a non-positivist, you may say, there's no basic norm and we need no basic norm. But I think apart from that, a non-positivist could actually use the structure basically in the same way. We can have a debate on this if you are interested in what I mean by saying that. Okay, the coercive act, the bottom, is a fact, and the fully concretized and individualized legal norm is a legal norm. Derogation is a relation between and among norms, so that the legal norm that is lower in terms of derogation does not count as a valid norm in the relevant legal system. As mentioned, there's a different relation at the very bottom, fully concretized, individualized versus coercive act. It's is-ought correspondence. A fact cannot be pronounced invalid or be invalidated. It can only be designated as an unlawful act. Designation lawful, unlawful. But it cannot, it's a fact, it cannot be invalidated. It's still there. So no derogation, at least not in the usual sense here either. So we don't have a problem. Derogation between and among levels of positive law. Now I'm coming, so to speak, to the final chapter here. Turning to the more difficult middle, the issue of derogation, the question is this. Is it analytically possible to imagine a system of norms without derogation between and among different kinds of norms? The answer is, in my view, yes, it is. It's analytically possible, just as it is possible to imagine a system of norms without the maxim lex posterior, derogat legi priori. The problem is, however, that such analytically possible systems of norms lack characteristics that are necessary for performing functions we ascribe to legal systems. That is the point. If one reversed the maxim lex posterior derogat legi priori to the effect that lex prior derogat legi posteriori, no one does that. It's just, so to speak, my attempt of spelling that out, would hold true. There was no legal power to repeal or amend any legal provision at the same level of superiority, since the norm to be repealed, amended, or changed otherwise would always take precedence over those legal norms that attempt to repeal, amend, or change the former kind of norms. The inevitable result would be a full petrification, turned to stone, petrified, petrification of the legal system. Thus, a key function of a legal system, permitting to adapt the legal norms in the system over time according to changing conditions and convictions or whatever changes, could no longer be performed. Such an inflexible, rigid system of norms cannot be a legal system because of the functions we ascribe to the system. And the same is a parallel, actually, argument. The same holds true for the maxim lex superior derogat legi inferiori. There are reasons why there are typically different levels of positive law that derogate from each other. Content at higher levels, in terms of derogation, shall be protected from being repealed or changed by norms at lower levels, which are subject to conditions imposed by norms at higher levels. For example, constitutional rights are supposed to set limits for parliamentary legislation. This presupposes to assume that constitutional rights derogate from parliamentary legislation. Otherwise, a parliamentary legislation statute would derogate from constitutional rights because of the maxim lex posterior, because it's later law. It would even be possible for the norms lower in the hierarchy of conditions to repeal the very legal power in the exercise of which they were themselves enacted in the first place. So to speak, killing the father, so to speak, Vatermord problem we would have here. A continued existence of legal power structured in a certain sense is, however, among the functions of a legal system. So you have to change the constitution if you want to change the constitution, right? You cannot do this by ordinary legislation. This is the function that is established by ascribing derogation here in the hierarchy of conditions. This is to say that the characteristic functions of the legal system render the hierarchy of derogation parallel to the hierarchy of conditions necessary if and to the extent that these functions depend on it. This applies to the relation between and among the typical levels in liberal democracies, from the constitution down to the level of fully concretized norms, the typical levels of national law. The same applies mutatis mutandis to the maxim lex posterior. This is also relatively necessary in a legal system that necessarily must permit the change of legal norms over time. Good. Now the question is, do I still have 4 minutes? And do you want to hear something about EU law? Otherwise, I skip that and leave it for discussion. European Union law, some of you look intrigued, is the difficult case. Well, at least you are so kind to look intrigued when I ask. Thank you for that. The difficult case, European Union law. Why? It's always funny. If I teach that stuff in my legal philosophy lecture, well, it's first semester. It would be more fun in the 3rd or 4th semester because students would have already heard doctrinal EU law. And now you're running into trouble because where does EU law go in this hierarchy? Good. Now there's also the classical question of international law. How does this go into the hierarchy? This is a discussion in and of itself. I haven't prepared anything here today. You can address this in the discussion if you want to. Now with EU law, the problem is it's a difficult case because EU law is lower than national constitutions in terms of the hierarchy of conditions, but enjoys some form of primacy over all forms of national law, including national constitutions. How can that be? well, maybe EU law is wrong, but maybe EU law is not wrong, but my approach to the hierarchy is wrong. So I have to at least deal with this to a certain extent. Two questions arise. First, is this possible at all, being lower in terms of conditions but higher in terms of derogation? Is this possible at all? And second, can this be reconciled with my reconstruction of the issue of the hierarchy? With an eye to the first question, I think the insight emphasized by Merkel, to some extent by Kelsen, that a parallel between conditions and derogation is not an analytical necessity, means that we can indeed disentangle conditions and derogations. It's a question of the functions that need to be performed according to my reconstruction. So yes, it's possible. Regarding the second question, the competences of the EU in primary law to enact secondary EU law and the content of EU law, for example, fundamental rights, provisions on the rule of law, and some others, are carefully designed as not to interfere with core elements of national constitutions, so that national constitutions do not necessarily have to insist on being higher in terms of derogation, even though the derivative nature of EU competence stemming from national constitutional orders. All sovereign rights of the EU are derived from national constitutional orders. They are granted to the EU. If a withdrawal happens, like in the case of Brexit, these sovereign rights are, so to speak, falling back to the national constitutional framework, if this is the right term for the UK as a constitutional framework. Good. It is obvious in the treaties and in the whole construction of EU law as an international organization and the principle of attributed competences in Article 5 Treaty on European Union, TEU. But why are national constitutional orders so generous in extending some form of primacy to EU law if EU law is lower in terms of conditions? This is not, of course, generosity. It is the fact that European integration is a constitutional end, following the insight that there are legitimate aims in the realization of which depend on European integration. So European integration permits us to do things that are good for us we couldn't do otherwise. So there's actually a constitutional mandate for doing that. In Germany, there's a constitutional requirement to participate in integration, and if Germany wanted to exit the European Union, actually its constitution had to be changed before we could do that. Good. I should also mention, this is also something that is interesting, that the primacy of EU law is strong primacy, but relative or conditional primacy, not absolute superiority in the form we know from the relation between the national constitution and parliamentary statutes, at least according to the case law of the German Federal Constitutional Court. If you read the precedents of the Luxembourg Court, the ECJ, things are different. I know, but this is the national point of view. Okay, all these are politically contentious issues, and the legal reconstruction is also contested. In our context here, EU law is only an example to test whether my considerations have some explanatory force, which I hope is the case. Let me conclude the example by saying that if I was asked to where to put this in the hierarchy, I would say, no, there it is. It is actually not in the hierarchy. In the hierarchies, if you want to represent both hierarchies, you cannot easily say that it has a different place apart from the Constitution. I would say that it is actually neither higher nor lower. It is a specific extension of constitutional law of the member states that is common to all member states. This would be my thesis of how to put EU law into this hierarchical structure. Good. To conclude now, actually, finally, is Merkel correct in saying that the issue of derogation and the maxim lex posterior are a matter of positive law? He's correct insofar as they are not analytically necessary in every imaginable system of norms, he is wrong insofar as the expression matter of positive law might be taken to suggest that you are basically free to assume or not derogation and the maxim lex posterior in a legal system with its specific functions. Owing to the functions of this particular system of norms or legal system, it is expected to perform in the national system. You are not free, you need it. Beyond the national legal system, it might suggest itself to disentangle the hierarchy of conditions and the hierarchy of derogation to a certain extent, as EU law, I think, illustrates, if the functions expected of law there actually allow that. Thank you for your kind attention.
Thank you very much for your intervention, Professor Borowski. And now we can open the dialogue about the questions. First of all, Mariano, please.
Thank you very much for the lecture. It was really interesting. And my question is, well, I don't know if I didn't misunderstand you. You assume more or less...
Sorry, there's the microphone. I think
Microphone.
people outside the room cannot hear you.
Thank you. If I didn't misunderstand you, you assume more or less the structure of the theory of Kelsen. I think that's my first question. If you, from a weak natural theory, natural law theory, assume more or less that this is a good description of a legal theory, is my first question. If this, with all the aggregation, all the things that you add to the theory, is a good description of a legal system in a constitutional democracy. If this is so, I will ask if what is the position then of Human Rights Act, an act, a statute of human rights, which doesn't have any formal superiority. For example, in UK, they have a Human Rights Act, which is not superior in formal terms, but any posterior act doesn't derogate this act. So, of course, judges have to apply this act, saying this is incompatible with human rights, but and they apply that statute, but that statute doesn't derogate the previous Human Rights Act, even without any formal superiority. And that is something that I think we cannot explain with this positivistic form of explaining a legal system. Thank you.
Yeah. Well, thank you. Yeah, I think I agree wholeheartedly, because what I presented here is the focus was on the analytical structure. And I only opened this, so to speak, very carefully when I mentioned that the basic norm is actually something that non-positivists might actually regard as superfluous or misleading. So, but this was a very, so to speak, tiny remark on the morality that comes into play here. What is, of course, not covered by this analytical structure is the moral dimension, which can be added and I think must be added. And this is actually also why I just briefly mentioned at the beginning that I'm not a positivist. And in this sense, if this exhausts what I think, I would actually be a positivist. Yeah. And what comes into play here is the issue of interpretation. And I would critically ask Kelsen, because Kelsen mentions as an example, when he talks about the relation between the Constitution and parliamentary statutes, he says, well, there can be in the Constitution, there are the competences, the organs, the procedures are characterized, how law is made, but then there also are limits to content. And constitutional rights are obviously in a constitution limits to content, because parliamentary statutes that violate constitutional rights are actually invalid. Now it depends on whether you follow, I don't know which theory you presuppose in Spanish constitutional law. In the German tradition, it is ipso jure nullity, so if an act is unconstitutional, it is invalid from the outset. And if the Constitutional Court pronounces that, this is just a declaratory act, which there can be centralized power to this declaratory act, but the fact that it is centralized does not render the declaratory act actually constitutive. This is what sometimes gets confused. Kelsen had a different theory. He thought that this defect made the parliamentary statute in question annullable, and this is the annullability. Vernichtbarkeitslehre would be the German or Austrian pronunciation. There are all sorts of differences, but the key point is a different one. The key point is, how do you actually determine whether there is actually a conflict between a constitutional right and a parliamentary statute? You need to interpret the parliamentary statute, but you also need to interpret the constitutional right. And I think, according to my theory, which I did not present, but you asked me, so to speak, to add to that part that I presented, this is where morality comes into play. Because how do you want to justify the statement that a violation of the constitutional right has happened in a certain place? How do you actually, if you use the weight formula, I don't know whether this was used yesterday by Arnolfo Matias Duran, but if you do balancing, then you compare the severity of the interference with the weight of the limiting right or limiting good in question. And how actually can you justify these statements on the severity of the interference without resorting to some form of moral content? And if there is if this justification of a violation, an application, balancing of a constitutional right necessarily presupposes to use moral criteria, then you have established a necessary connection between law and morality, and this is actually, I think, a connection that is there. But it needs to be made. I was not, so to speak, focused on those. And now you mentioned the Human Rights Act. I have the benefit of some first-hand experience because I had to spend some time there, and they generously allowed me to do that, so to speak, during a part of my career. Having a Human Rights Act which has no formal primacy over parliamentary statutes is, in my understanding, a incomplete transformation of moral rights, human rights, into the law, because of the importance that human rights as moral rights have. They demand that they are enforced with the force that is characteristic of law. So law, in essence, is a moral tool, and it adds to morality what morality as such does not have, that is enforceability, structures, authority. And the Human Rights Act is probably better than nothing, but it's not an adequate or sufficient institutionalization in law of what human rights as moral rights require morally. But it's I would say it's a moral defect. And, but this is, at the level of national constitutions, some systems do that. Germany, after World War II and the atrocities of the Nazis, has chosen to a completely different path, but I have also, as a German, I have to admit that our British colleagues have a lively democratic tradition over more than 300 years that Germany does not have. So we have catched up a little bit in the second half of the 20th century with some things, but there are some impressive achievements by the UK system, yes. But the Human Rights Act, I think, is not something that is particularly impressive. But this also applies to some legal instruments for the protection of human rights in international law. The Strasbourg court with the individual complaint is an exception. and in Europe we tend to think as the kind of typical structure in international law. It is not. It is often about reports, it is often about recommendations. If you take the International Covenant on Civil and Political Rights, there's a facultative protocol on the individual complaint, but even if the state signs the complaint, and even if it happens, it's not, deliberations are not public, and then a decision is arrived at, and this is a recommendation. This is arguably not legally binding. There's some debate on that, but so this is not something that is completely isolated. It's more a phenomenon we have in international law. But yeah. Okay, I should stop here because otherwise it's becoming a second intervention. But yeah, I think the point was very good, and this is something I left completely out because you have to focus on something. Otherwise, the presentation gets very long. Thank you. Thank you for this interesting and important question.
Professor Triagovas, a member of our research group who is following the session online, sent me a voice note with some questions, so I'm going to play it. Let's see if you can listen well.
Good afternoon to everyone, and please accept my sincere apologies for not being there. As I speak, I'm currently traveling from the south of Spain back to Madrid. So the first question I would like to ask regards the interaction between the concepts of power and norms. So not being well-versed myself in Kelsen's, let's say, juridical ontology, I was always puzzled from his insistence in modeling his theory in terms of a structure on whose top you have the concept of a basic norm, and from there you have a derivation of less basic norms up to the point of their application as individual norms to particular cases. So my question is, would it be possible to replace our talk, discussion, and use of norms as the items that make up the structure with a concept of power, such that, for example, we could talk about the existence of a basic power instead of a basic norm, and instead of talking about applications of norms, to talk about the exercises of powers up to the very point of exercising the ultimate power, which is the power to coercively impose a certain form of conduct. And the second question I would like to ask, if I may, regards the relationship between the concepts of a legal order and a legal structure. So in my understanding, there are moments where the concept of order implies something more of a horizontal relationship. In which sense? In the sense that it is more like a sequence of derivations or inferences, if you like, from premises to conclusions. Just much like an ordinary logical argument, which is horizontal in its progress. Of course, it's directional, it is asymmetrical, it begins from a specific point and it goes to a specific direction, but it's nonetheless horizontal. On the other hand, the concept of structure implies something entirely different. It implies something about the existence of inter-level relations, or relations between levels, and how one level explains the other level. So I was wondering how within the Kelsenian framework, these two very basic intuitions about what makes law could be, let's say, accommodated without producing internal tensions. Thank you very much for your attention. And once again, my apology for not being there with you. Bye-bye.
Yeah, thank you. No apologies needed. It's actually amazing that you listen to my talk while on the move. So actually, no, thank you. I'm not sure that I actually grasped this second point. It may be, this was a recording, right? Yes. So back and forth was possible. But because someone might know to which he refers, and someone might be able to explain to me what he means, if someone feels.
He also sent me a raw question, if maybe I can read it, and it's not clear. The second question is talk of legal order and legal structure intersubstitutable? Orders imply a linear derivation or deduction or cause of consequences from premises, and structures seem to imply relations among vertically located levels.
Vertical, and yeah. Yeah, yeah. I'm still. I'm afraid I don't get it fully. The first question, to just begin with that, the question: can we replace norms with power? It depends on what you mean by power. Not easily. If you legal power. If you use legal power for what is meant in German with Ermächtigung, that is the legal competence, is a legal position which allows you to change, create, amend law. It's just a change of words. And for Kelsen, norms and facts are two completely different categories. And Kelsen is insisting that you cannot replace norms with facts. And he fights at two fronts: against natural law, this is the morality problem, and he also fights against positivism, or factual positivism, that intends to reduce the law to facts. That is legal sociology. Eugen Ehrlich, before Kelsen, stated that legal sociology is the true science of law. Nothing could be more wrong for Kelsen. This is completely wrong, misheaded. To mistake legal philosophy, law, with legal sociology is among the worst mistakes you can make for Kelsen. So factual power can't be it. And the basic norm, this whole structure, is actually devoted to the question that Kelsen has. How can we actually speak of a normativity of law? How can the ought be distinguished from the is? How can we present a solution that can be reconciled with Hume's law, David Hume? The distinction between is and ought, that invented is probably the wrong word in philosophy, but that was pointed out by David Hume. And then in terms of influences, Immanuel Kant was influenced by David Hume, the is and ought. And from Kant, both Hans Kelsen, who is not only a neo-Kantian but also has some Kantian elements, and Gustav Radbruch, who is a neo-Kantian of a different kind, and also has some Kantian elements in his theory. This line of German traditions in legal philosophy all accepted Hume's law, according to which you cannot derive an ought directly from an is. You need is and ought, and the ought is the legal power. It's that normativity. And in that sense, probably my answer to the first question is no. Because there are only these two categories, norms and facts, at least for Kelsen. And to replace that with power, that neither means norms in the sense of normativity, nor power in the sense of factual power, it's not possible. I don't think it works. At least I don't see, as a reconstruction of what Kelsen does, how he could accept such a thing. This is, as I mentioned with the basic norm, this is far less of a problem for natural lawyers, depending on how they precisely characterize the relation between, the necessary relation between law and morality. But if law is essentially a tool of morality to fulfill moral ends, then law is, so to speak, at the beginning, in the first place, a part of morality. And then that some normative dimension comes into the play in what is morality is normativity. This is about ought, what ought to be done to achieve a just solution, to arrive at justice. So morality is normative from the outset. And if law is, so to speak, only an instance, a kind of tool or element of morality, then what's the point of the basic norm? Interestingly, Robert Alexei, who has this strong connection between law and morality with his argument from injustice, but also has this broad, all-encompassing, but weak connection between law and morality established by the correctness, argument from correctness. Why does Robert Alexei need a basic norm? He has a basic norm in the system. I don't think he needs one, actually. But normativity is a difficult topic. It was touched here with the normative power thing. This is why I mentioned this, so to speak, again after the presentation. I'm still not sure whether I got the second question. My impression is that it was aiming at the question, this is a kind of vertical top-down approach. He
tried to explain again the second
Oh yes, second attempt. Yeah, and I will listen to that before I say anything.
I may offer an explanation on the second question. I would say that I tend to understand the concept of order as a generic concept that goes beyond the notion of illegal order, and that concept implies something about a horizontal relationship between premises and consequences. Of course, in the case of law, these premises and consequences can take the shape of norms, but nonetheless, I understand the progression from these premises to the conclusions as more like a horizontal progress towards a specific end, which is the drawing of a specific conclusion, as opposed to the case of a legal structure, where I tend to understand the way we logically work the structure in terms of explaining how one level grounds a level that lies above that other level. And that, of course, again, can also be applied to the case of norms, where norm stands in hierarchical relations to each other. So my apologies once again for the noise that you are hearing. I'm sorry, I cannot avoid that. I'm just at the train station. Thank you very much once again.
Okay, no, thank you very much. No, the problem is not the noise. The problem is that your question is intellectually challenging, which is, of course, should be. Okay, well, with the horizontal vertical thing. And I know that, yeah, well, okay. A crucial operation that we undertake if we answer legal questions is interpretation. And I didn't talk much about interpretation. We just covered this with the kind of moral dimension. Kelsen's theory of interpretation is strikingly simple. For him, is interpretation moving from one level to the other. And this was mentioned when I talked about the relation between law creation and law application. Okay, so this in some sense tells you what things need to be taken into consideration if you apply one of these norms. Now, this vertical scheme can, of course, be brought into something that can be called horizontal if you just create a structure of premises and conclusions. So in that sense, this vertical structure can be transformed into something that strikes one as more horizontal. But the fact remains that even in this, the idea is of this whole thing, I think, is to impose order and to, so to speak, understand crucial dependencies that in the legal systems exist. It's about imposing order. And if there is a conflict, this is now the issue of derogation, if there's a conflict between norms, you just look at which levels are these located, and then if they are at the same level, if superiority is the same, then posteriority comes into play. Now, posteriority, lex posterior, of course, is something that not necessarily closes the issue. It is often one's consideration in interpretation. And in some instances, you say, for example, if we understand this statute as meaning that, then it would change a former statute. We don't want that. And this was definitely not what the legislator wanted. So this is a consideration that is used in the reconstruction of interpretation. I think, and I don't know whether if we look at the core process in applying the law, legal interpretation, which might include subsumption and balancing to a varying extent. I don't know whether the distinction between vertical and horizontal tells us that much. But it may still be, and I don't want to ask you for a third round of explaining the question. I apologize, I may not grasp it, so to speak, fully. So I suggest that we
Thank you.
move on, sorry.
I have one more question here in the chat. Okay, Carlos Aguilar asked, within the pure theory of law, what is the role of judges today in resolving conflicts in the legal system?
Judges.
Which is
Yeah, judges. Yeah.
Mm-hmm. Okay. Yeah. Interpretation establishes a frame. In H.L.A. Hart, and the theory of Hart is quite similar to Kelsen's theory. For Hart, it's language, and it distinguishes between the core of certainty and the penumbra of doubt. When it comes to the core of certainty, well, the law has taken the decision, and it's just the judge's task to pronounce what the law has already, so to speak, set. If we are on the penumbra of doubt, I might add that there's also a third zone that Hart doesn't speak of. This is the zone of negative certainty. Hart doesn't speak about that. Then it would be certain that the legal consequence of that norm to be interpreted does not apply, but there's the interesting penumbra of doubt. Kelsen uses language, and he uses also legislative intent. I think Kelsen is a bit more interesting on the interpretation front. But Kelsen adds that the language is unclear, legislative intent is unclear, and actually, if both were clear, the relation between and among the wording and legislative intent is unclear. These are fundamental issues of legal interpretation as we know them. And so he is not so sure about the frame, how to establish and how clearly this can be established. But if a frame is established, if it is a possible but not a necessary interpretation of the law, the judge is a law creator. The judge continues the task that the legislator did not finish, purposefully or accidentally. These are two different categories Kelsen distinguishes, but the judge, inside the frame that interpretation establishes for him, is a legislator. This is legislation. Full stop. As simple as that. And Kelsen insisted, also this is important also I think for the modern reconstruction of balancing, that there is no single right answer. So the thesis with which Dworkin became famous, or we could say notorious, and what does this mean precisely to have a single answer? Is it a single answer that A can be done or B? Alternatively, is this a single answer, or is it only a single answer if you say only A can be done, A must be done? So there are all sorts of problems involved, but this is, I think Kelsen was very good in inviting attention to the fact that interpretation establishes a frame. And if you have modern reconstructions of balancing, I think something along the lines that he presented yesterday probably, then there is discretion. And I think this is a Kelsenian insight. And Kelsen distinguishes authentic interpretation from non-authentic interpretation. And in some sense, you could also distinguish authentic balancing. If the Constitutional Court is empowered to undertake balancing, it's, so to speak, authentic balancing. And all these very learned doctrinal law professors commenting from the side. This is this, so to speak, narcissistic wound that Kelsen inflicted on every doctrinal legal law professor. They are only doing non-authentic interpretation because they are not empowered to anything. They, so to speak, they just make suggestions, which can be very clever, and of course judges are very happy to get some suggestions, but technically this is non-authentic. So legislation, so to speak, is the function.
Thomas?
Which is, of course, wrong from a natural law perspective, because the frame is narrowed by moral considerations, possibly. Yeah.
I have a comment that I wanted to submit to your opinion. I've always thought that Kelsen's theory on derogation follows his considerations on validity. And according to the general theory of law and state from 1960 and from 1946, and the second edition of the pure theory of 1960, he insists on the concept of validity as something called specific existence of the norm. And I have always thought, also following some, I would say, some careful study of Kelsen's theories, along with other analytical theories such as Hart's and some of the more recent contemporary Italian doctrine on derogation, that possibly Kelsen misunderstood the problem of derogation following this concept of validity. And why is that? Because derogation has probably no concern with validity as existence, but with applicability of norms. So, following the more contemporary analytical theory, applicability could be general or could be specific. For instance, an abrogated norm could be applied ratio tempori to a case that we know by now, because the facts were produced during the validity or the general applicability of a norm. Let's say a crime occurred under an derogated law has to be analyzed today according to that derogated law. So, by saying that, the more recent theory on derogations sees it not as a problem of validity as a specific existence, like in the so-called Kelsen's pyramid, but with regards to applicability. So a judge, as the last question stated, what does he have to do with a derogated norm? First, he has to see if it's generally applicable to the case, or it's generally applicable now, and also has to see if a norm is specifically applicable to a case by now. Could be derogated or not. So, my comment to you that I want to submit is that probably Kelsen saw the derogation problem as validity problem, while other analytical theorists, more contemporary, I would say, following more language than internal logic, have concluded that derogation has more to do with applicability, which is not necessarily something bind to a specific existence.
Yeah, that's terribly interesting, and without knowing much about the modern theories you referred to about applicability, this sounds very plausible to me. And there is something going on with Kelsen and validity and derogation. And I mentioned his theory of normative alternatives. Yeah, and he is, for a reason I have never understood completely. Kelsen refers to positive law, interestingly. He says that an unconstitutional norm that has been socially effective after it was enacted, he says that has validity, even though there is no legal power to enact that norm. He assumes that has validity. And this is why he needs to explain why there is something in the first place to be invalidated. This is why he comes up with these normative alternatives. And it basically says you are empowered to enact a parliamentary statute that is in conformity with constitutional rights, but you are also empowered to enact one which is not. And the second, so to speak, unintended, in some sense unintended version is necessary for the norm to be valid, so that there is something that can be invalidated by the Constitutional Court. And I never understood why he not simply uses the German ipso jure nullity, which would be perfectly in tune with the idea of legal power being granted not to enact unconstitutional parliamentary statutes. Yeah. Okay. Now, with the validity and existence, and applicability means that the norm exists but is not applicable. No. Because we have the problem, and this is also relevant in the debate on the morality problem, we have the distinction between concepts of law omitting and embracing validity. You want to say something?
Yeah, an example. Foreign law.
Yeah.
Foreign law is not valid here or in any country, but it's applicable to some cases. That's the case with abrogated legislation. You can apply an abrogated legislation to a case now. It's not valid according to a specific existence or a logical structure of a legal system, but it's applicable. So derogated norms are applicable to cases that come to knowledge afterwards, but during the time that they were valid according to a specific existence. So what I'm saying is, that Kelsen's view is focused on validity as a specific existence, as he says, and not on applicability. And with language now, with the language analysis of the analytical jurisprudence following Hartz and some others, Italian authors, Claudio Luzzati and some other, you come to with the realization that applicability is a term that corresponds to the problem of derogation and not validity. That was my comment.
Okay. So, and the point seems to be here that the validity criteria are, so to speak, included into the set of criteria of applicability. They are deprived of, so to speak, some special importance as designating a specific category of the application of a law. And this leads to the question, this strikes me as a possible interpretation. Kelsen was asked whether this actually confuses fundamentally different things into one category. And he was obsessed with the normative interpretation of factual material, which is emphasized by Hume's law. This was his concern. And the supporters of factual positivism, basically realists of one of the other kind. This distinction plays a role particularly in Radbruch's theory, because his formula has two parts, the interoperability formula and the disavowal formula. The interoperability formula is an interpretation, but I think it's something that can be demonstrated, leads to the loss of legal validity, while a defect with an eye to the disavowal formula deprives the norm in question of its legal character. Now, this is very important for Radbruch. He's obsessed with that to some extent, and he applies the disavowal formula, not the interoperability formula, as many commentators would have us believe. And interestingly, this has no practical consequences. No practical consequences. For Radbruch, he says the disavowal formula, this can be established easily, so the certainty of cognition is different. But once you have established that there is a case, it makes for the judge, it makes no difference whether something for Radbruch is not law in the first place, So the validity question actually cannot be meaningfully asked, and we don't ask whether this bottle has legal validity. It's something that is not capable of having that property. So for a judge, it doesn't actually play a role at all. And so the question is whether this is something that can be included into one and the same set of criteria. And it could also be, the rapport problem could also be phrased as an applicability issue and not as a derogation. It's the rapport formula is a derogation of positive law by morality. It's a derogation problem actually too. Interesting. Thank you for inviting the attention. Good. I have to look into this applicability thing. It's interesting. Thanks.
If I may, insisting of that idea, do you think that that difference between applicability and existence? I mean, it could be useful to explain the doubts you have explained about the European law. I mean, that perhaps after the basic law, there is not a problem about the validity of the European law regarding the Constitution, but it's a question about applicability. So there is a structure of the law from the Kelsenian point of view.
Yeah.
And then there is another thing that the Constitution, with an international reflection to the international law, to the constitutional treaties of the European Union, and this is another classic problem of international law.
Yeah.
Accepts the Constitution,
Mm-hmm.
accepts, or I don't know, the basic norm implicitly accepts that could be an whole, that could be an sphere of non-constitutionality law that could be preferably primary, has a preferable applicability than the Constitution itself. And that is not a problem about hierarchy. It's a problem about applicability between them. But the idea of primacy of the European law is that.
Yeah, I argued in a paper devoted to Neil McCormick's reconstruction of EU law that this primacy issue between Constitution and EU law is a matter of balancing. With a formal principle. We are approaching deep waters here again. But the point is that the Constitution, so to speak, permits, for the sake of having a successful and fruitful European integration, that something the Constitution would require, if this whole thing would not be there, is not respected. But my insistence, so to speak, that EU law in some sense integrates into the Constitution means that we have to distinguish the Constitution, the national Constitution without EU law, so to speak, before EU law comes into play, and the Constitution writ large, that is, the Constitution permits and requires European integration, and by doing so, something, for example, I don't know, environmental protection. So the common market permits something which may not be true. If there are environmental campaigners among you, I don't know. Requires that some kind of economic development lowers the standard that would be constitutionally required in Germany without European integration. And this becomes then, in some sense, a preference decision, balancing, I would argue, between different aims and ends which are constitutionally relevant. And problems and paradoxes only emerge if you, so to speak, look at the national constitution in isolation and at EU law in isolation, and then you see it as a conflict between two different things, while at the root, so to speak, that there's the European integration is a requirement of the Constitution. It's not something that green aliens imposed on us, having landed in flying saucers and say, EU, now live with it. Our politicians sometimes argue that way after having voted in a specific sense in EU institutions for political and rhetorical reasons. But it's something, EU integration is something the Constitution wants. And the German Constitution, as I said, there is a constitutional requirement. So the political powers are not at liberty whether to actually engage in integration or not. They are required to do so unless there are serious defects with rule of law, no protection of the Constitution. It's basically the Solange requirements written into a constitutional article in Germany.
So if I understand well, is mutation of the Constitution or is a variation of the basic norm?
The basic norm is always empty.
Okay.
The basic norm never changes, so the basic norm is always empty. It only, so to speak, is there for to have a non-moral normativity on which Kelsen was insisting. So I wouldn't argue with the basic norm at all. Everything that is being done at the level of the Constitution, this is where content comes into play, and the basic norm is I think it's not changed. This is, of course, part of this extended debate on the basic norm, whether if the Constitution changes, if there's a revolution, whether the basic norm changes. And Kelsen, I think, added to the confusion by kind of having some language that kind of implies that there can be different basic norms, which I think goes against the idea of a basic norm. This is always one and the same.
But is the idea the basic norm in the pure theory of law of 1932, not in the version of the 1916?
Yeah, all sorts of changes come into play in 1960, and this book, this is why I teach the 1934 version. I have to say, if at least, so to speak, for first-year students to kind of get into the classical idea, but of course, I warn them that things change. Things changed, of course, more after 1960, but the second edition is already a different book. I think it's 5 times as long as the first edition. All sorts of things come into play. And also this, I think, notorious idea that authentic interpretation is lawful even if it cannot be reconstructed as being based on legal power. All these things come into play in the second edition. I agree. A periodization of Hans Kelsen, we don't have Stanley Paulson here. He would actually give a lecture on his on the periodization alone and actually taking us through all the things. I cannot claim to be that much of an expert as he is. But I think this, and this is why I chose the topic, the structure has some value for us, and cases such as the European Union law with all the politically contested implications, I think we need solid and valid legal reconstruction, and so to speak, this is part of my attempt of contributing to that. Much of legal theory in European Union law is, I think, done by political scientists and people who are very much inspired by legal sociology. And I think many of them, if I come with this kind of hierarchical idea, they just throw me out of the room because I insist that there is some element of hierarchy. So, hierarchy doesn't work, it's all pluralism, and it's kind of cooperates and relate to each other. Which happens, but I think the idea of this hierarchy, and I think this is an idea we cannot dismiss, is to impose some order. Morality comes into play, some sociological processes come into play that fill this with life, but this, I think, is still needed. And I like universal and eternal things. At least I try to talk about them. Thank you.
Any more questions? Yes, Benito.
Yes, I have a question about isn't there a positive elements regarding Hans Kelsen? Yeah, kind of paradoxical way of arguing the normative in the sense like, take for example his idea of the creation of the law by the judge, the discretion. They were, at the time he was writing, there were certain theories that were searching in the world of, in the realm of fact, of is, that a specific fact that put in jeopardy the whole normative structure, that fact that could not be inserted in the normative scheme. Like, for example, the political decision of Schmidt or the emergence of commerce of Pachucanis, in the sense that what Kelsen argued, his insistence sometimes in the normative, in the role of, in the creation role of the judge, has also positive elements, like, for example, it tries to rationalize in a certain ways political power in a very like kind of complicated way. And my question is are there other elements, like you talk about rigidity in the structure of Kelsen, but actually when we took the basic norm, like law have no specific foundation, I think it opened a law to change, in the sense that there are other interpretations that try to derive the meaning of law through history, through sociology, and they attach law to a very specific part of history, to a very specific understanding. So my question is, yes, this structure has problem. The idea of the basic norm has problem. His profound separation of the is and of has problem. But is there also like positive element in Kelsen thought?
Well, if you ask whether I think there is a positive element, I did not want to present his theory in an entirely negative sense. Well, obviously, as an academic, you honor a theory with criticism. This is the greatest praise you can give to a theory, is to devote attention to it and then criticize it. This, of course, is of utmost importance when we ask about imposing order. Then, of course, it is about distinguishing acts that are law and acts that are not law. We may here actually have a debate on a certain issue. We may come up with a parliamentary statute. So we make law here as a group, Friday afternoon. We come up with a parliamentary statute that is absolutely amazing in terms of history, morality, positive morality, being connected to other parts of the legal system. It's just we come up with the substantively perfect parliamentary statute. So it would be, yeah, perfect in substantive terms. The problem is, unless I don't know anything about you, no one of us has been elected democratically to enact law in this process. So, and law is about justifying force done to people who don't want to do anything, to punish people, to steer people's behavior against their autonomous decisions. And this is what law is about. And so what counts as law and what does not count as law is of utmost importance. And I think what this scheme does is giving us some elements that we need to identify what counts as law and what does not count as law. Now, this is positivistic. This leaves morality out of the play, and this may come into the play at some point. But this is of utmost importance, and it also has to do with the separation of powers. This structure of the legal system and the theory of legal interpretation, Methodenlehre, nowadays is not only something that is, so to speak, the the operating system of the law in a given legal system, it also has enormous constitutional implications. Because that judges, for example, here who enact individual norms, that they actually have to do this inside a frame that is drawn by the Constitution and parliamentary statutes above, means that democratic decisions need to be respected. If a judge were empowered just to do anything, and this is why I'm so upset about Kelsen's idea of that wrong interpretations of the law count as lawful. It is an issue of finality. I know there's a problem there, but this performs important functions in liberal democracies, and this allows us to identify law from not law. It's not perfect, but this scheme contributes to that, and I think because of that, it's of utmost importance, actually. Yeah. And approaches you mentioned, Pashukanis and Schmidt. Schmidt, of course, Carl Schmitt. One of the German gifts to the intellectual world, Carl Schmitt. Apologies. Yeah.
We have 4 minutes.
There is one more question in the chat.
Okay. Go ahead.
Okay, Carlos Aguilar makes another question. He asked, is there any justification in Kelsen Pure's theory of law to allow many cases today to be resolved discretionally with legal rules or principles? So if there is any aspect of Kelsen Pure's theory of law that justifies discretionality using legal rules and principles.
Yeah, thank you. Kelsen is clear on legal principles. They don't work. He doesn't do balancing. He says no balancing. It's just to speak, moving the problem from one side to the other, and there are no criteria for deciding competitions between competing principles, and so he doesn't do that. Although he argues on the basis of constitutional rights, interestingly. So I would, if Kelsen would be here, I would ask him, you can't do this. The whole system doesn't work. If you have constitutional rights in the Constitution, how will you do this without balancing? So directly, Kelsen rules out principles. They are not part of the legal system. He has a system of rules only. This is what he says explicitly. Now, I think what Kelsen does when he talks about traditional interpretation of rules, by insisting that the methods of interpretation do not lead to a single right answer, but that there's always a frame of interpretation, and the judge has choice inside the interpretation. If you apply that, which I think can be done, to what we do in modern reconstructions of balancing principles, then Kelsen's forceful point in the reconstruction of rules can be objectively applied to balancing. And in that sense, Kelsen is a forefather, against his stated intent otherwise. Kelsen is a forefather of a theory of discretion in balancing, but indirectly, and against his explicit statement, so to speak. But it would be interesting, well, all these questions in history, what happened if history went differently? It would be very interesting to listen to a debate nowadays between Hans Kelsen and Robert Alexy. Robert Alexy is a non-positivist. The argument from correctness would be useless for Kelsen. And from injustice, Radbruch, this doesn't work. He rejected this flat out. Perfect. We know what this would be. But when it comes about the analytical side of Robert Alexy's, I've actually called his theory, and I begin to like that once I've said this, try to characterize Robert Alexy's theory as analytical non-positivism. And he has a strong analytical side, Robert Alexy. It would be interesting to see a debate between Kelsen and Alexi on the analytical side of Alexi's theory. If Kelsen would be willing to talk to someone who entertains these morality things. But it would be interesting. And I get, well, I don't know. I'm not neutral. I support the weight formula and this all kind of stuff, so this is a debate. But I think that Kelsen would be intrigued about the idea of the weight formula and the theory of discretion connected to the weight formula and its application. I think Kelsen would be quite happy with this discretion thing. But in some parts of Kelsen's theory, Kelsen does things that surprises me, having read other parts of this theory. So I don't know, maybe I'm just too optimistic. But it would be interesting.
So we are out of time. Last chance. Professor Borowski, thank you very much indeed for your presentation and for your discussion.
Thank you very much for allowing me to present here and for actually interesting and far-ranging questions. Thank you.
Thank you very much.
Thank you.
So, thank you.